Jonathan,
Teddy,
thank you so much for doing this.
happy to be here.
We've obviously known each other for a long time, but I think this is a great opportunity to, take a step back, learn a little bit about your journey, your life story here, how you got to this point, which I've never really actually gotten the chance to sit down and talk to you about. So I'm excited to do that.
Let's do it. It's good to have a little bit of free time these days.
I feel like maybe a good place to start actually is with your family and with your grandfather. I know you kept papers of his in your office, and I was wondering if you could start off, tell me about that and tell me about him.
My grandfather is a hugely influential person in my life. He was a plumber. He dropped out of school in order to support his family. Uh, Came to this country as a 1 year old from Kiev, actually, and was just this wonderful guy, tough as nails, golden gloves boxer, but just this wonderful, warm, tough on the outside, soft on the inside kind of guy. And I remember um, a few things about him. First, going to the plumbers union. He was a plumber, and we would go to he's retired, but we would go to the union and hang out with his union buddies. And he's like, "Well, Grandpa, where are we going today?" He's like, "Going to the union and play cards." And that really defined his worldview. He would beam with pride. He would, as we would drive by elementary schools where he installed the plumbing, because he believed he was part of building the infrastructure for this country that was then used to educate children. He understood the role that he played, not just in providing for his family, but building the kinds of buildings and necessities of life that allow others people to thrive. And he would talk about how um, proud he was the day he became a U.S. citizen. And so I kept his papers, citizenship papers, in my office every day at the Department of Justice.
And so, how did he shape you and your family growing up?
So um, he is an inspiration for that. You always work hard and you always give it your all, right? And you don't back down from a fight, right? So but you treat people with dignity, respect, and warmth. So he was this loving, warm grandfather who was big and stocky and would fight, when he was younger in the ring as a Golden Gloves boxer. Um, he, when you need to support your family, you work really hard. You give it your all, but you do it with great patriotism. You do it with great respect for the country, and you treat people around you with dignity, sincerity, and honesty.
And I wanna skip ahead a little bit because you've got this rich background, and then how did you end up in law school? Like what drew you to going to law school?
So I'm a blue collar, well, not blue collar, but middle class kid. I grew up with elementary school teachers for parents, went all the way through public school system, including through state university. That was just sort of my way of doing things growing up in Queens, New York. And I always had an interest in law, even going back to high school, and was on a mock trial team and, all that kind of nerdy stuff. But I really loved it. And so I always kind of had a sense that law school was likely to be in my future. I loved public policy, and became really taken with making a difference.
And was there any connection, just with your family background, your grandfather? Just did you have a sense at all that things were not just, or that things were not fair for the working people? Was that part of what you were thinking, or was it more just a general interest in policy and law?
It was actually the not that. So it took me a while to really come to that. I grew up really believing in the American dream, believing that if you work really hard, you can realize a better life than those who came before you, and that this country offered opportunity to everybody. And to me, the American dream was owning your own house and owning your own business. To me, those are the two like shining points that define who we are as a country. It was control over your own life. And so I did not come from an upbringing where I felt like the system was unjust, or that there were um, forces working against the American dream. As I got older, as I witnessed more of what I was seeing in the business world, I both at the same time believe that businesses are critical to the operation of our country. At the same time, became concerned that our economy was becoming too concentrated, which was choking off opportunities for others to build and grow and develop exciting businesses. And I was becoming concerned that concentration in our economy was limiting our freedom and access to the kinds of pathways to the American dream that I, held so near and dear, like home ownership and like the ability to be entrepreneurial and start your own business.
And did that realization uh, was that triggered when you got to the FTC, or what brought you to the FTC after law school?
So I was interested in working in Washington. I did both my summers as an intern at the FTC. Great job. And I worked on pharmaceutical issues. And I remember as a at the summer of my first year after law school, interning at the FTC, we were doing an investigation into two drugstores. And this is like a great example of like why you just want why the details matter. And so every day I would sit there and go through boxes of documents. And at the time, the boxes were really boxes of documents. Today, everything's reviewed on the screen. Back then, we'd have file rooms full of massive amounts of documents that we'd subpoena. And I remember looking at um, a coupon or a promotion that one drugstore was running, and the other drugstore had that promotion in its files. And okay, that's great. You're just trying to like keep track of what your competitor's doing. But then I looked on the document and I noticed it was a fax because that was how people, and it was a fax from the competing drug store the day before the promotion ran. And I was like,
Wow.
why is the competitor faxing a future promotion to its other competitor the day before it was supposed to run?
A hot doc via fax.
Exactly. But you sort of realize like it was like on week 4 or 5 of reviewing boxes of documents that I found that. And we you kind of have to stick with it. You kind of have to dig in.
And so you go from the FTC, you're cracking down on monopolies, and then you go into private practice. Tell me about that. How did you make that decision, and what did you learn when you were in private
Yeah.
practice?
So when I was at the FTC, I very much believed in what we were doing. I very much believed that the work in antitrust enforcement made our business community more honest, and it made our world more fair. At the same time, I was not an ideologue, and I didn't have any. Um, I believe that there were important roles to play, as I do now, on both the offense and defense side. And so I went to a law firm. I had student loans and wanted the opportunity to do something a bit different. And so I had a good experience, in private practice. And for the first, number of years, a lot of the work that I was doing was centered around uh, um, just traditional merger defense and the monopolization defense. I worked a lot on the US v. Microsoft case and the settlement in that, and so learned a lot about monopolization. And then over time, I started doing more work playing offense. So my practice ended up being kind of a mix of defending companies who were under investigation, but also representing companies of all sizes, including big companies, who believe that the antitrust laws and enforcement of the antitrust laws, fair enforcement, would actually make their business opportunities better and create a better economy, not just for consumers, workers, and others, but for businesses as well. And so it was it was interesting to see both perspectives at the same time.
And one of the things I get concerned about when people go into big law is that they will basically get indoctrinated into thinking that the law is actually meant to protect business, right? Like that they conflate their job with how the law should work. How did you sort of maintain an open mind and still think creatively and have some grounding, integrity of how you think about the law working for those companies and going through that process because I definitely see a lot of people they go into big law and they kind of get lost I think intellectually and so I want to ask you how did you.
Well, it's easy to get into a filter bubble, right? And so when all you're doing is defending mergers and all you're doing is hiring experts who tell you that everything is, good, it becomes very difficult to see the other side of the equation. And listen, your job as a lawyer is to zealously represent your client and really be as forceful as you can be in representing your client. But what I observed was that the community became indoctrinated, not just the lawyers who are working on a particular matter, whether it was the ABA or academia. There was a lot of money tied up and self-interest tied up in preserving and promoting certain ideas. And I saw the goalposts moving in real time. And there was not a lot of community of interest and not a lot of neutral work being done to talk about why enforcement was necessary. There were some, but it was far outstripped by the investments that were coming into defense. And what I found was that, particularly in the academic community, whether it was law professors or econ professors, that many, if not most of them, were working for defense firms or companies or advising. And so there was this major conflict of interest between the work that they were doing in their academic careers, which were designed to search for truth, and the work they were doing in their professional careers. It almost became like a two-sided market where really the academic career was designed to create a credential that can then be used to then be monetized for other purposes.
And did you have an aha moment? Was there one moment where you just thought, you know what, something is wrong here? We need more enforcement, or what? How did you come to that view?
Yeah, I'd love to say there was an aha moment, but there wasn't. It was really gradual transition where over time, I came to appreciate, particularly as the internet economy was taking hold, that there were dangers. And I think when started to appreciate that, particularly when you deal with data-based, data-driven technologies and services, there's a real tendency toward tipping. I think we have a real danger that if you don't create competition or preserve competition early on in the development of one of those markets, over time, it can be very difficult to retrofit to create that competition. And that there was a lot of the companies were starting to play a longer game, which was they would lose money for or not generate revenues in either in their entire business or business units for an extended period of time because the market would ultimately value the long-term monopoly opportunity. And so the companies would be worth eye-popping amounts, even if they weren't turning profits. And it created this sort of different business world and different business reality that I feel like was completely ignored by the antitrust laws and the antitrust community, which was, continually and still to this day too focused on short-term profit maximization, not focused enough on long-term empire building.
And so let's skip ahead. I know you end up starting your own firm. You break off from big law, start your own firm to do the sort of advocacy work full time. But how did you end up at the DOJ? Like, how did this desire to do enforcement get you to the DOJ? And tell us the story about how that happened.
Yeah, so starting with my own firm, I guess I would say that it was a blast, right? I realized there was a gap in the market, that there were a lot of companies, big, small, and everyone in between, who actually wanted to advocate in favor of enforcement. But you didn't really have any law firms that focused on doing that with the same level of quality and precision as big law. You had plaintiffs firms, but they were focused often on class action and private civil litigation, not on advocating in front of the government, really to offset kind of the defense strategy. And so my goal was to build a law firm that was focused just on that, where it would only do that kind of work. And it was an interesting entrepreneurial initiative that had no billable hours and valued time based on different measures, valued valued the legal work based on different measures other than time. We paid full competitive salaries, and so if lawyers wanted to come out of law school or leave big law and do work that was pro enforcement but had financial obligations, they can come work for us and actually make the same kind of money, but do so representing um, um, clients who wanted to promote enforcement of the law. And so it was a really successful and fun endeavor. I really loved it. And then I got tapped on the shoulder to come into DOJ. That is a very opaque process, and one that has all sorts of forces working in all sorts of different directions in terms of how people get selected for positions in government. Obviously, antitrust was both the head of the Antitrust Division and the FTC chair were hotly contested positions because they were seen as really important weather vanes for where we're going to go in terms of economic policy. And it was an honor of a lifetime, and not just to be nominated, as they say, but to get the opportunity to work and at the Antitrust Division as the AAG.
I want to talk more about DOJ, obviously, but I actually want to go back for a quick second to your law firm. What how do you see that market now? Are there other firms that are doing what you did? And like if you were giving advice to someone who wanted to start a similar law firm or a similar practice, how would they think about the opportunity now?
So I guess, starting with the last question, I think there is, there's more, there are firms that are doing that. Some of the folks that I used to work with are still out there doing that work, which I think is great. And I'm seeing more boutiques pop up and boutiques that are more comfortable taking on pro enforcement work. I think that is a byproduct of a more pro enforcement um, government environment. And so when you have the DOJ, the FTC, and state attorneys general bringing antitrust cases, doing investigations, it creates greater willingness for third parties, for businesses who are harmed, for workers who are harmed, for consumers and others who are harmed, to step up and invest in giving the government the information it needs in order to investigate sensibly, accurately, and then, if necessary, bring cases. And so I think it's kind of created this expanding community of interest that has, I think is just starting to take off. I think that against the backdrop of AI and has created opportunities, I think, to succeed and to have viable law firm businesses that are smaller and more focused and more specialized. It used to be that in order really to do a lot of the tasks, you needed scale, right? And so document review, for example, is a massive expense and still probably one of the largest generators of billable hours. But I think technology is actually working in a beneficial way to help lower some of those costs. And in fact, when I was at DOJ, I viewed that as one of the most existential threats to the Antitrust Division, was keeping up with the vast amounts of documents and data that we had to review just to conduct an investigation, let alone litigation. So well before DOJ or the Department of GE, we were investing in and building our own AI models to help lower the costs on frontline document and data review so that we can investigate at scale, and so that our talented expert attorneys and other professionals weren't spending in disproportionate amount of their time, sifting through, frontline review of documents, but instead working to curate those materials so that then they can spend their time focused on building and marshaling that evidence to bring a case.
And was that intentional to sort of uh, push the envelope of the law or just bring more cases, just more monopolization cases? The FTC brought Robinson Patman cases, you brought algorithmic price fixing cases. And these are now all kind of cottage industries in the plaintiff's firms, state AGs looking at doing similar investigations. Was that intentional, or was that just a byproduct of reinvigorating the law?
Both. So it was very much intentional. And I was very clear about this when I started, that the antitrust agencies had fallen down on the job in terms of enforcing monopolization, right? I mean, think about our antitrust laws were built to take on monopolies. Um, Section 2 of the Sherman Act is the cornerstone of antitrust. And if you ask anyone outside the antitrust community, what is antitrust law? They'll say it's about monopolies. Yet somehow we weren't bringing any monopolization cases at all. And at the same time, against the backdrop of this huge public awareness that there were monopolies popping up everywhere throughout our lives, and a huge backlash against the development and frankly ubiquity of monopolies in almost every industry. And so absolutely we need to bring those cases. One of the problems I think that created a chilling effect on monopolization cases was this sense that the law wouldn't work. But that was not true, right? I think there was an overreading of the law and a kind of creating of a boogeyman around cases like Trinco and others that, yeah, they made it a little harder, but not impossible. And so we moved with great urgency to conduct investigations when we believed that there were potential for legitimate concerns about monopolization. And then if we saw a problem, we would move to bring a case, and we did so. We were able to shrink the time it took to investigate, and then we were able to build monopolization cases around market realities. And so by that, what I mean is, instead of just looking at kind of these traditional cookie cutter cases, we started with how does the market really work? Where are the moats? Where are the choke points? And then build the monopolization cases backwards from those, rather than trying to reverse engineer from a few economic models.
And so I want to talk about that a little bit because, um, you know, you make a couple of points there. Market realities, the law being strong. Having been a student of this myself, it does seem though that rhetoric and economic theory were actually very powerful influences on everyone in this ecosystem, right? Judges, enforcers, even pro enforcement advocacy groups historically have had this pretty narrow lens from consumer welfare, largely as a result of the rhetoric and sort of economic theory that stemmed out of, uh, you know, Bork and other people kind of doubling down on the consumer welfare test. Um, how did you how did you think about overcoming that, not just at the agencies, because like obviously a lot of people at the agencies are also part of that legacy. How did you overcome that from an intellectual standpoint? I know one thing that came up a lot was, rigor over routine, challenging status quo. But how do you instill that in like a large organization, and how do you move forward with such a, you know, really it's taking an idea and fighting the consensus, overcoming the consensus, and that's been very powerful and dominant for two generations almost. I mean, it's a long time.
Right? You have to do it from within, right? You can't. It's sort of goes back to Max Weber and all the kind of bureaucratic theory. Like you can't come in, declare that things are different, and then expect everybody to go along, right? If you want to inject new ideas into the institution, you have to bring people along. You have to listen to them, and you have to um, build enough trust so they listen to you. And we invested heavily in building that internally, and explaining what we were doing and why, explaining the legal infrastructure. We brought in different voices and experts, and we didn't shun expertise. We just expanded it. And we said, okay, if we want to understand how technology markets, we need technologists. If we want to understand economics of healthcare and healthcare markets, we need healthcare experts. And so we started expanding the scope of expertise. And then we started doing a deep dive on the law, and demonstrating that, okay, the law actually is a far more flexible, particularly on Section 2, than people appreciate. And so one of the tricks that the defense bar had instituted into the way we think about antitrust is that everything in Section 2 has to be narrowly put into a bucket. This is tying, this is refusal to deal. And by putting into a bucket, it became outcome determinative, so that if something's characterized as a vertical restraint, you can basically figure out where it's going to end up in the law. And so what we tried to do is move away from that, rigid categorization, and start thinking about how do we build cases that actually reflect market realities. And so let's unpack that for a second. Markets are no longer just horizontal and vertical, they're platform like, they're ecosystems. Okay. And so the economics that underlie a lot of the cases that we find problematic no longer actually accurately reflect the um, the markets as we find them today, right? And so you can look at cases like Aspen Skiing, which found a violation, and then you can look at Trinco, which didn't find a violation, and say, okay, well, um, yeah, those are interesting principles, but Trinco dealt with digging into the dirt and actually the capital intensive efforts to lay infrastructure and wires and poles and the like. That's different than the economics of building out a network where there's very almost zero a cost to adding an additional person, unlike a phone system or a telecom system where you actually have to sort of invest in the infrastructure. And so a lot of the economics that underlie Trinco no longer apply in the technology world. And so you can start distinguishing facts as a way to distinguish the law.
And let's talk about, Section 2 and, the cases that you're most proud of that came out of the agency, and sort of what you're most proud of in terms of the legacy of it, just really radically increasing the number of Section 2 cases, monopolization cases, and also, I think also reversing a trend of, look, you guys took on the biggest companies in the world, right? So and some of the ones that where people like Ticketmaster, where people just feel viscerally upset about. How did you which of these cases are you most proud of, and like how do you see your legacy around Section 2?
Sure. Let me just take a step back on that. I mean, we again we were very deliberate in our case selection and where we invested our resources. We have scarce resources, right? Um, the day I finished at the Antitrust Division, we were over 200 fewer people than 1979. We were woefully under resourced relative to the task at hand. And so we have to be very thoughtful and careful about how to use our resources. I think there have been a lot of very fine line drawing that took place at the antitrust agencies where there was a desire to bring the perfect legal test case every time with the rationalization that, okay, we're going to move the law in the right direction and that's going to change everything. But I think that ended up becoming the tail wagging the dog. And so we developed a methodology that I call HIPS. And I'd say, put your hands on your hips. And what that means is it stands for high impact, programmatically significant, right? And so when we're thinking about how to prioritize our cases and use our resources, we focused on high impact first. What's going to impact society the most? So that impact can be financial impact, it can be impact on workers, it can be impact on socially or important issues like the dissemination of news and information. It could be moral impact like healthcare, which is both moral and um, economic. And we really thought very carefully about which cases to focus on. And as a result, we focused on the biggest companies engaging in the conduct that we believe was most harmful to our economy. And so if you look at our cases, who did we sue? Well, we sued, the biggest companies in the world. We sued um, Apple and Google and United Healthcare and Visa and RealPage and the landlords. We took on meat packers as part of our AgriStats case. We went through the biggest issues affecting the most people in the biggest areas of our economy, and then we brought the cases there.
And you mentioned you have resource constraints. Maybe you could take a step back and, you're at DOJ, you're seeing all this concentration. You can only bring so many cases. How much left is there to do on concentration in the US economy? And like, if you give us a scale of like 1 to 10, how bad is the concentration problem? And like, how much left of it do you think we have to go?
We just scratched the surface. And so, from 1 to 10, we're like at 15, right? Like we're just getting started here because we're basically, um, you know, opening the this up after 40 years of one way of doing things, and so now we're taking a fresh look at the economy, and we're seeing choke points everywhere. And because of the market realities relating to data and other things, if you look at healthcare, if you look at tech, if you look at um, so many other areas, they're far more concentrated than they ever were, and they have a tendency toward concentration that didn't exist perhaps 30 or 40 years ago, because more markets, sort of have these sort of feedback and technical and network effects. So it's really important to be mindful of all that. So the problems are there, but we started taking them head on, and I will say that part of our goal to take on monopolization cases was to make sure that we had a path to mergers. So one of the things that happened over the last 30 years or so is the agencies focused almost entirely on merger work and very little, if at all, on monopolization and conduct work. And the reason why is because these HSRs, Hart-Scott-Rodino forms, would come in, the merger filings would overwhelm the agency. They'd have to investigate. They'd throw a lot of people in those investigations. They would take a year and a half on the big deals, and it would consume massive amount of resources. The process of investigating a merger, a second request, is hugely document and data intensive, and so it would consume almost the entire um, fleet of the entire workforce with respect to civil cases. And so part of what we need to do is we needed to, and a lot of these deals should never have left the boardroom in the first place. And because the agencies didn't have the resources to litigate, they ended up settling a lot of these cases with divestitures. And it became this sort of vicious cycle of concentration that was largely built out of necessity because of the volume of HSR filings. And so, one of the things that we really wanted to do is make sure that we pushed companies to curate their deals more on the front end. And one of the things that I had observed in my time in the bar was that over time risk had shifted from being shouldered by the seller in a merger to being shouldered by the buyer. And it used to be that the seller, if the deal didn't close, it would be devastating. They wouldn't get paid. Their resources um, would would deteriorate, and the value of the business would be left. So you know, the industry came up with ways to shift that resource, the risk, to the buyer, and so the buyer would pay big breakup fees. The buyer would agree to do all these things in terms of settlements, divestitures, and other kinds of commitments in order to get the deal through, and that would lower the improve the risk of closing for the seller, which meant that the seller was willing to take a higher premium or a higher purchase price from a strategic buyer that had antitrust issues, because most of that risk was going to be shouldered by the buyer. And so one of the first things I did when I got into office was I announced that we were no longer going to favor divestitures and mergers as a foregone conclusion, as an acceptable remedy. And so we would do it from, occasionally, but only if it really fixed the problem. And the reason we did that was, one, um, the data and our experiences at the agencies demonstrated that many of those divestitures fail, right? And once they fail, there's nothing you can do to fix it. And two, if sellers were concerned about risk of closing, then they would be more selective in determining which deals to enter into and which buyers to contract with. And I'm pleased to say that we really, while we didn't solve that problem, I think we improved it dramatically. And during our time, we saw sellers being more um, careful and scrutinizing of problematic buyers, and entering into fewer problematic deals on the front end because of the risk of closing. And that, while it didn't stop the bad mergers, it slowed them down considerably, which freed up resources that we can then use to investigate and bring monopolization cases.
So I want to stay on this for a quick second because I want to get your opinion on why you and Chair Khan became so loathed by the antitrust bar. Part of it is okay, you broke up their way of getting these complicated deals done. That seems like one issue. But there's got to be more to it. They're making tons of money defending companies from monopolization cases. I get why Wall Street is mad because they can't do whatever deal they want, right? But what was your take on the sort of emotional reaction from like the Wall Street Journal op-ed section, the ABA? Where does all that come from? The sort of visceral antagonism, to, just aversion to new ideas. Like how do you explain that?
Yeah, so you had a system that was built based on a certain way of doing things, right? And so people had invested in this sort of technocratic language and process, and they don't like people coming in and disrupting it. It's bad for business. It makes them um, um, more vulnerable, I guess, commercially. And it also it can get personal, right? If you spend your entire career, as I did, frankly, you know, sort of buying into this one philosophy, and then someone comes along and says, well, maybe we need, some of that was wrong, right? You're saying, well, does that mean that I was wrong? And does that mean that, I was not good at my job? Or does that mean you're suggesting I wasn't an effective enforcer, or the articles that I wrote were not worth anything? And so people come very defensive, and because it's disruptive. And I think, I lived through that world. I come from big law and the antitrust establishment, so I get it. On the other hand, over the trajectory of my career, I had an honest conversation with myself and said, okay, how much of this is working and how much of this is broken? And I encountered a lot that I felt was broken. And I saw from the inside out that a lot of the models we're using, a lot of the methodologies that we're using, and a lot of the techniques that we were using really weren't effective. And they often were increasingly gerrymandered for outcomes rather than to solve problems in a honest, accurate way, even if they were well intentioned. And so, change was necessary, and that's hard, but I think it's important.
It's just funny because I remember having a conversation with this one lawyer. He was so mad that his deal did not get a second request because he's like, "Oh, these tough enforcers, it's going to get a second request. I'm going to bill all sorts of money." So on the one hand, he was clearly happy that there was more antitrust enforcement, more second requests, more scrutiny because it meant more money from him. But then 2 minutes later would just be just using the most vulgar language to say how displeased he was with you and Lee and Sherkan personally. There's something that just doesn't totally make sense to me, but changing their, sorry, I guess challenging their worldview and their sort of philosophy that they've bought into for their entire career actually is more a bigger deal to them than money.
It is. It's both, right? So I know a lot of the folks who were involved in the Reagan era when they kind of disrupted the antitrust bar back then. And I remember hearing from people I worked with and are friends of mine stories about how they basically came in and stopped bringing cases, certainly, or not stopped, but dialed down enforcement. The antitrust bar was furious, right? Because they had their way of working, they had their expectations, and now all of a sudden these whippersnappers from the Reagan administration were coming in with their Brooks Brothers suits and ties and their preppy attitudes, and they were shutting everything down in the name of a more conservative way of doing things. And so the same level of outrage occurred when folks came in and did too little, just as much as the same kind of outrage occurred when we came in and did too much. I think that's a symptom of change. I think that's a symptom of somebody questioning the establishment and the establishment fighting back. And so I didn't take it personally, even if people on the other side did. I will say that it was also it was funny because one of the things I hear now is sort of a lot of revisionist history, even though we're only out of office a few months. People saying, "Oh, well, they just enforced the law at the same volume as other before, and they blocked this many mergers and they blocked that many mergers." And I'm like, really? Because that's not what you were telling me, a year ago. A year ago, what I was hearing from the antitrust bar, and I was hearing from bankers, and I was hearing from advisors and companies, was that deals that otherwise would have been done were not getting done, and that the deterrent effect from our work was real, not just real, but significant. And it made them very angry, right? Because now the kinds of strategic M&A that would have occurred, 5, 10 years earlier just wasn't happening. And so They were very angry about that. So both things can't be true. You can't tell me on one hand that we were too aggressive and that they're angry we were too aggressive, and on the other hand say that we didn't do anything. When I look at our track record, I'll speak for us at DOJ. I think the same is true at the FTC. We sued Ticketmaster, Apple, Google. We sued United Healthcare. We sued Visa. We sued the meatpacking industry. We sued the RealPage in the rental industry. We took on NAR and realtors. Like, we went after the biggest problems. We brought some of the biggest cases, any one of which would have been a defining moment for an administration. But we did so in volume, and both in terms of the volume of commerce and significance of our cases, as well as the volume of cases itself, in ways that we haven't seen in 75 years. And so I think our record speaks for itself, notwithstanding the effort of folks who have a strategic and economic interest in trying to redefine what we actually did.
I want to move on a little bit to how you think about what's going on now. Now, the Trump administration has taken over. The new leadership has decided to keep your merger guidelines, to keep your new HSR filing form, to commit to continuing with a lot of the big tech, pretty much all the monopolization cases that have been brought. We've seen some. So it seems like this idea is actually has survived of more robust antitrust enforcement, and your sort of rigorous approach to digging into the law has survived in a bipartisan way. But I want to get your reaction to that, but how you think about there's the flip side of the Trump administration is that they're not allowing any more hiring. You already have a resource constraint at DOJ, and you have this attrition and this sort of I don't want to call it terrorism, but like sort of fear that they're instilling in a lot of government employees intentionally. How do you see antitrust enforcement going forward? And then maybe just want to get your reaction.
Yeah, let me try to unpack that a little bit. So let's start with kind of the guidelines and some of the monopolization cases. And they were built to survive, right? We did not build them to be ideological in the sense of partisan, right? Not to build, for Republican or Democrat administration. We actually built out from principles that are very familiar to conservative lawyers, which is focus on the law as written and as interpreted by courts. And so I'll give you an example. When I got in, we knew we were going to take on the merger guidelines. So I asked my team, I said, I want you to write me a memo, and I want that memo to essentially describe, outline merger law. But I want you to do it without the merger guidelines. I want you to do it just by looking at the cases and the statute. And at the same time, I want you to print out every merger decision ever decided since the inception of the Clayton Act. And I want you to put them in binders and leave them on my desk. And so we spent the next number of weeks, months, reviewing all of that. And when the memo came back, we found something that I had kind of instinctively known as a lawyer, but wanted to demonstrate to everyone else, which is that if you read the memo that describes merger law based on just the law, it was in one place. And if you compared that to the existing merger guidelines, what you saw was this massive divergence. The merger guidelines were not written based on the law until we came along. They were written based on someone's view of what they think good merger policy is. That's the wrong way to do it. So we said, okay, we're gonna start with, what does the law say? We're gonna start with what are the cases, binding precedents in appeals courts and Supreme Court say about law, whether we like them or not, and then we're going to work backwards from that. And then we're going to use a strong legal basis, and then we're going to figure out, okay, how do market realities function, and how do we look at the facts of every merger against the backdrop of the law. And by focusing on the law first, it became a process actually quite familiar to lawyers, quite familiar to courts, one of the reasons I think we had a fair degree of success, and frankly, quite familiar to conservatives because that's the process they use and advocate for in their legal philosophy. And so I think we built it to survive. The other thing we did is um, this was a big issue for me, was we stopped, we got away from very stylized models, right? So, for example, the first question an antitrust lawyer would ask when they got a merger, the first two questions are, is it vertical or horizontal? And what are the markets and market shares? Those might be actually very important questions to ask, but they were the wrong first question to ask. And so we wanted to build, and I wanted to build the guidelines around a principle that was, first question is, how does competition in this market work and how does it present itself? And then the second question that we're trying to solve for is, does this merger threaten to substantially lessen that competition? And then from that, we can look at lots of different tools and market realities to actually focus on how competition presents itself. And what you realize is that, it doesn't always fit a model, right? Sometimes competition is idiosyncratic. Sometimes it's like a platform. Sometimes it's like a conglomerate. Sometimes there's cross subsidization. Sometimes there's innovation. Sometimes it's traditional competition with two grocery stores sitting next to each other. All of those different things play in. Sometimes it's about recruiting specialized labor. Sometimes it's about roll-ups, and that the right way to think about a merger is understanding how it fits in with the four mergers that occurred before it. All of those are market realities that are addressable under the law. But to do that, one, you need to define and explain what the law says. And then second, you need to actually figure out how to apply it to the world as we find it today, not the world as we may have found it in a textbook 40 years ago.
What's amazing to me is this like, oh, this is going to be a reality-based analysis. I had a hard, I remember hiring antitrust lawyers when I first started the Capital Forum and asking them, well, why are they doing this merger? And they would call up the antitrust lawyer and give me the explanation the antitrust lawyer gave. I go, well, obviously that doesn't make any sense. I want to know why, in reality, the executives are doing this merger,
Right.
not why, not the excuses that the antitrust lawyer came up with to argue that it's okay. And then I then spend all my time with this red herring exercise of like disproving nonsense, right? Like
Right.
in terms of like
You,
intellectually understanding things.
yeah, you're disproving a made for government argument,
Yeah.
as opposed to trying to figure out why is the deal actually being
Yeah.
done. And
Yeah.
listen, people can say, "Oh, that's not how it works." Everyone in the antitrust industry knows that's how it works,
Yeah.
right? Companies will decide to do a deal, and then they'll give it to their antitrust lawyers, and the antitrust lawyers say, "Oh, shoot, now I've got to retrofit an explanation that has quote efficiencies as the leading reason, even if that was not a reason even at all." Right? And so it was more about truth seeking, and that actually goes to the merger form, because again, this is another conversation that I had, right at the outset of my tenure, because I had lived through this. Um, the reason to revise the HSR form, to understand it, you just need to look at the old HSR form, right? What any antitrust lawyer will tell you is that the HSR form, almost all of every question on the HSR form has nothing to do with the antitrust analysis, right? It is ignored had been ignored by the agencies, because the information you were asking for in order to analyze a merger, um, and the HSR form wasn't relevant to the antitrust analysis. It was mostly designed to determine whether you paid the right fee, right? And so much
Yeah.
so that the agencies would have their own questionnaire standing by, and actually lawyers in the private practice would have their own questionnaire standing by that they would send out and say, well, if the agency is going to review your deal, they're going to want the answers to these questions. And what it was doing is it was making the process really inefficient. It was taking longer to review deals because you actually had to go through this dance rather than getting it as part of the merger notification. You had to get it through follow up and through this, kind of informal process. And whereas it'd be much easier to figure out which deals are worth a look, not if you got all that information in the first request, which is the Hart-Scott-Rodino merger notification form. So it made a ton of sense to update that, and it made no sense to continue using the old form because it was wildly out of date.
I remember the private equity companies being the most angry about that because they had to list all the companies they owned. And that was a really hard thing for the staff to get a hold of when they were wanting to do a quick look at a merger when private equity was involved.
Right, which is exactly what you'd want to know if you were investigating a merger,
Yeah.
right? And so the idea that that information wouldn't be the idea that you wouldn't in order to figure out whether the merger affects competition, you need to know what people own, right? Like this is like basic stuff that wasn't adequately addressed in the previous form. And so, yeah, we plugged some of those holes and we made it relevant to the analysis. Otherwise, why have the whole form in the first place?
So let's skip ahead. You know, uh, Trump administration takes over. Like you said, keeps sensibly, to your mind, keeps the merger guidelines, the HSR form. It's sort of bipartisan consensus. These just are necessary. We've got all these monopolization cases. Obviously, have a lot of state AGs on that as well. That sort of makes it bipartisan. A lot of those cases. Um, but you did have a lot of people saying, "Oh, hey, we expect the Trump administration to settle these on the cheap." Obviously, we that could still theoretically happen, but it doesn't seem like that's where we're headed. Even on NAR, which you mentioned, DOJ still sent out a brief supporting Rex Holmes after you left. And uh, Gail Slater said in her confirmation hearing that she wants to keep competition in housing a priority for DOJ. So it just doesn't seem like on the big questions that you're seeing sort of a bipartisan consensus here. But I do want to contrast that, if you'll let me, with the staffing problem that they're going to run into with the sort of attrition, the doging of the government. And it doesn't seem coherent to me. It seems like a problem to me, and I wanted to get your take.
It doesn't seem coherent to me either. So, as I said before, you can't have an effective organization unless you have people who are on mission, unless you have people who are working hard and believe in the work that they're doing and have the right incentives. And you can't be a good leader if you're just telling people what to do and not listening to them. So you need an organization that is healthy, that is sufficiently um, large. And a lot of people, particularly in the antitrust community, come to work at the agencies because they believe it's the right thing to do, and it offers a lot of job stability and is more enjoyable often than working at a big law firm. And so, you don't want to scare those people away because it's a very competitive market and you don't pay as much. And so I devoted a lot of time and effort because it was necessary and it was the right thing to do to really build, an institution. I very high standards. We worked very hard, and I made some, major structural and other kinds of changes inside the organization. Not all of which were universally popular internally, but always did so with great dignity and respect. I am hopeful and have every reason to believe that the incoming folks at the antitrust agencies will do that. But they're doing it against the backdrop where people who work for the government have been sort of villainized and vilified, and where rather than like, so I'll give you an example. Like they honors attorney hiring, and why would you, if you were trying to control, make your department more efficient, the last thing you do is hire the people who are really qualified but paid the least, right?
Yeah.
And you would figure out ways to, as most companies do, if you really felt you needed to get rid of people, you'd figure out how to deal with people who are underperforming, or you try to help, encourage natural attrition through buyouts, things that we did. You wouldn't kind of indiscriminately, without regard for whether they're talented and how much they're paid, just revoke offers or fire people. And so that's not a way to make government more efficient. That's the way to eliminate government. And so if your goal is to eliminate government, then sure, just fire people indiscriminately as often as you can, whatever the easiest path to do so, pursue it. But if your goal is to actually save money, make it more efficient, then there are better ways to do that. And so while I'm very optimistic about both the FTC and the DOJ, and I think they have people who are genuinely devoted to antitrust enforcement, and I'm optimistic or cautiously optimistic that things will continue in a good way. And I think with very good intentions, and they'll do a good job in their own right. I do worry about what's happening more broadly at the government and what's happening to the federal workforce. Because I think, again, while there are always ways to make it better, more efficient, less expensive, I'm down for all of that. I think the kind of way in which it's happening is not necessarily conducive to achieving that outcome.
Let's talk a little bit about, and I know I've kept you for a long time, but I want to talk about the biggest problems. You mentioned the hips, uh, high impact, programmatically significant. Let's talk about what I think is sort of consensus as the biggest monopoly issue of our time, which is big tech and its control over the communications system. Um, Obviously, you supported Google, two cases against Google, brought one, enforced one that was brought during the first Trump administration. What is, if you take a step back and think about it holistically, what is the threat that big tech represents to the US, to our society?
I think you can look at it so many different levels, right? So let's start with just the economic level, right? One of the biggest costs for small businesses is customer acquisition, which is advertising, things like search advertising. One of the revenue generators for publishers, people who create news and other information that's critical to the political discourse, is having the technology in order to sell advertising, right? And so when you think about our Google cases, what we were focused on are really important economic issues. I mean, the amount of money that is flowing through these systems is extraordinary, and it's a major cost. Lowering that cost alone would be a huge benefit to our economy and good, right? Having it be more competitive.
I've actually heard stories about people say that it's so expensive to get customer acquisition online that they are opening storefronts. Like like D2C companies are like, no, we're gonna open a storefront because it's actually cheaper to acquire customers that
Right.
way, which is insane to me.
Yeah.
But
So the
yeah,
economic impact of search advertising or other kinds of advertising are huge, right? And I think um, you know it would be irrational to say that it's not an economically important issue. Same thing when you look at the digital economy, right? When you look at the cost of smartphones or the cost of developing and monetizing apps and services that run online, like all of those things are hugely important um, from an economic perspective, setting aside the social impact. Um, on top of that, you take the innovation, right? And so there have been a lot of great innovations that have come out of, even some of the companies that we've sued. But what we're concerned about is that, innovation, should constantly be pushing forward. And let's face it, competition drives you to innovate. Competition drives you to think about new ways to solve problems. And when I look at a lot of the problems, whether it's privacy and security and, addiction to devices, we need more folks innovating in those areas, safety and security. We need more people coming to the dance and competing. And so if companies are engaging in conduct that stifles competition and makes that harder, then that is absolutely something we should be concerned about. And then there's the kind of political impact, right? One is when you're dealing with communications platforms, the distribution of information. It's important to elections. It's important to inform society. The spread of misinformation, disinformation is something that is extremely important to our way of life, and I think so many people would agree has become a real problem that companies who are in this industry have not innovated enough to solve those problems, but instead have exacerbated and accelerated those problems. Second is our economy is too dependent on a small number of players. People talk about the Mag Seven and whatnot, but if you look at our indices, two of those companies suffer a catastrophic incident, it could tank our entire economy, right? And so we are not diversified in terms of the kinds of businesses that we have. And then, there's sort of the kind of broader political question. And there's a good visual for this, which is the inauguration, where It was held inside ostensibly because it was too cold to have it outside. And so take take a snapshot of that day. You have the rank and file supporters outside freezing their butts off, right? And then inside you have the CEOs of Apple, Google, Meta, and Amazon, nice and cozy and warm, sitting next to the what will soon be the new cabinet.
In the
Um,
front row,
in the
in the front
right,
row,
right,
in front of
right,
congressmen.
right.
Yeah.
That's the kind of level of political influence and control and impact on our economy in direction of our country that I think concerns people, and that is one of the reasons why we have the antitrust laws. And it's not to suggest that when we do an individual investigation, we have a political influence meter. I think people misinterpret when we talk about antitrust as being important to democracy and political power. It's not that you measure whether two companies compete based on their influence over politics. It's understanding why we have antitrust laws in the first place. Because if we have an economy that is too concentrated, those concentrated entities can exert an outsized influence over our political system. So the goal is to preserve a competitive economy. And the goal in our antitrust analysis is to preserve competition because that's the value that leads to these wide ranging intended benefits, including a more resilient and decentralized economy so that we are not over dependent on a small number of players, including um, um, diversifying and the voices in the political process. And I think, particularly against the backdrop of the outgrowth of things like the Powell memo, which have given corporations in outsized role in our political process, when you add that plus concentration, it becomes very dangerous.
I want to come back to the Powell memo in a minute because I'm also similarly kind of obsessed with that. Um, when you talk about the threat to democracy, I think one of the concerns that, my wife certainly brings up and people I know bring up is, are we actually going to have a democratic election in the midterm in the next presidential election? Or, is it just a fait accompli that Facebook and Google will just turn the knobs in favor of their preferred party for the indefinitely? Like, are we going to have free and fair elections if we don't have open communications systems that aren't rigged? Is that a legitimate concern? And B, how far, if it is, how far does the antitrust cases get us to solving that? And like, taking a step back, how do we comprehensively address that?
So, yeah, I mean, I think most Americans or people across the world will say, of course, that's a concern, right? The amount of information that is flowing through a small number of platforms and the way in which that information influences people, in both an obvious and insidious way, is something that we have to pay attention to. And while there have been a lot of innovations around how to sell ads and a lot of innovations on algorithms to show you things that they think you might be interested in, there hasn't been enough innovation on figuring out how to solve these kinds of problems of misinformation and disinformation and abuse of these platforms in order to influence elections. And I think there's a real important conversation to have about that. The role that antitrust plays kind of goes to the point I was making earlier, which is a more competitive economy. One, gives us more people at the table with innovations. It gives the people the ability to vote with their feet. So if they don't like what they're getting, they can go somewhere else where they might get better information. And it means that it dilutes the influence of any one of those platforms, so that if they're failing to really deliver good, accurate information, or they're finding themselves having um, being manipulated for the purposes of an election rather than being used for good purposes to give people accurate information, then at least if there are a lot of competitors, the impact will be diluted. Those are things that antitrust can address. I don't think they're substitutes necessarily for election security and national security. I mean, they all have to work hand in glove.
Let's come back to the Powell memo, because one of the effects of the Powell memo was to sort of like erode, or not erode citizens' rights, but to give corporations the same rights as citizens over time, right? Take away, you know, uh, make it impossible to enforce campaign finance laws, and basically give corporations the same free speech rights as individuals in the press. Um, and then obviously we've had Section 230, which is a change to communication law that gives almost blanket immunity for platforms to not be liable for stuff that goes on the platforms by their users. Um, so we've got antitrust right now is really the only law in town that big tech really is worried about, because anytime another law or regulation threatens them, they just say, hey, I have First Amendment protection, or hey, I have Section 230 immunity. And the Supreme Court in particular has had a real problem grappling with this. And I'm curious to get your views on this. The way that I think about it is, honestly, Thomas and Alito are the ones who are open to uh, communication style regulation of big tech, right? Common carrier style regulation of big tech, because their power is so obviously great. What's the solution when it comes to Section 230 or freedom of speech to get us to where we need, where these companies feel accountable to the law?
So do something, right? Let's talk about tech. I mean, I kind of, chuckle when I hear, you know, around the time of the election, folks in the big tech world talking about being overregulated. Think about all the data that's collected on a daily basis, right? Think about how much of personal data is used. Think about the massive amounts of effort that goes into extracting information from your phone and from your browser. We don't have a single, well, we have almost no privacy law. The main privacy law in the United States is the FTC Act at the federal level, which was written well before the internet, right? um, I mean, we can't get anything through. And that's because, one of the things that people in Washington appreciate, that it's really easy to stop things. It's really hard to do things. And we've had people, really good people on the Hill, who've tried to do things, but the tech companies have so much power that they can kill almost anything. And so not only are they not regulated, there's negative regulation. Section 230 is negative regulation. It carves out immunities that other, kinds of businesses don't have. And so it is probably the most, relative to its size, impact, and the invasiveness of its business, it is probably the most unregulated industry in the history of this country.
Let's yeah, and I want to ask you about freedom of speech, because as a media company, I read the First Amendment and I see, well, the only company mentioned here is the press. The only type of company mentioned in the First Amendment is the press. But then you get big tech, which is, and I'm a, full disclosure, I'm on the board of Digital Content Next, uh, as a member of that association. And this is an industry that is the press that is being materially harmed. I mean, just continually, uh, the business opportunity for media is narrowed by big tech.
Right.
The opportunity diminishes to have advertising based businesses, and you just, it's just not sustainable. And yet, those are the companies that do have explicit First Amendment protection, and they're being destroyed by companies that are claiming First Amendment protection against regulation to help, ostensibly help them. I mean, it's like a dystopian reality. And I want to bring back the Powell memo, because ostensibly the Powell memo has been like too successful. You've got even Republicans on the Supreme Court saying, "Hey, maybe we've gone a little too far here." The big tech needs common carrier rules on them, despite their claims of First Amendment protection. What what is it about? What do you see? But on the Democratic side, you don't see that. You see Democrats kind of saying, "Yeah, I do see that point. The big tech needs First Amendment protection." What is it about? Why are Democrats in favor of this like First Amendment maximalism when it comes to corporations having speech rights? Like, that's something that to me just doesn't make any sense, but that seems to be the reality that we're in.
Yeah, I mean, I think there's no one answer. A lot of it is political fundraising. To the point earlier, when you have really, really big companies, they become very powerful and they become very important to elections. And the more that fundraising becomes important in elections, the more power they have, right? And so that's, just the basic math of it, which is unfortunate. And I think has resulted in a lot of rationalizing, and compromising on things perhaps that are otherwise should be addressed in the political process. And notwithstanding that, you have some very brave, members who have, stood up to these issues, including, the on the Democratic side, like Senator Klobuchar, who's introduced a lot of legislation and tried really hard and was really a big support of the work we were doing. But it's kind of gets it to a stalemate. I think it's there are a lot of different there are I'm sure there are a lot of other answers as well, some more cynical, some others, but it's we are in a world where uh the political process is impenetrable to average citizens, but easy, or much easier to navigate and more accessible to very wealthy companies.
We went down a bit of a dark path here, so I want to end on an optimistic note. You met with a lot of young people, a lot of students. Um, clearly, uh, there's some energy around what you and enthusiasm around what you and Sher Khan were doing. What are you optimistic about when it comes to the sort of the ideas that you brought up while you were at DOJ, continuing, and the sort of movement that you started, persisting going forward?
I do actually have a great deal of optimism around antitrust, and it's for a few reasons. One is I visited, I think, over 30 schools during my tenure, and people are coming out for antitrust. There's this incredible interest, and it flows from a genuine, authentic belief that corporate concentration and corporate power can deprive us of our liberty. It comes from a place believing that these are important problems that need good solutions. And that's encouraging, because when I was in law school, people would come out not in those numbers for antitrust. And if they did, it's because they wanted a good paying job, right? And so there's this real belief. I would also say that I've been really struck by how that transcends partisanship. We've had really great engagement with people in the Federalist Society, and folks who are card carrying conservatives, many of whom I would probably disagree with on a lot of other things. But when it comes to these issues, believe that the concentration of corporate power is just as dangerous as the concentration of political power. I think that is a symptom, or the direct proximate cause of what has been too little enforcement, and too much tolerance of corporate concentration and power, and a belief all sides of the political continuum and ideological continuum that we need to do something about it. And so it's one of these rare pockets kind of in the Washington and legal communities where you're starting to see some agreement, not uniform by any stretch, but some. And I think that's encouraging, and I hope that continues. And I think it's a good opportunity for people to talk to each other rather than at each other and past each other. Um, I'll also say that I think a lot of that is a function of age. A lot of the people who are coming up through law schools, and the younger folks in our agencies and law firms, and in the sort of policy world, lived through the financial crisis as perhaps one of the most influential economic events of their lifetime. And they saw the pain and suffering, and they saw a world in which companies that inflicted a lot of harm were treated with kid gloves by the government, whereas the people they loved or their families were asked to suffer and bear and shoulder the burden of other people's failures. And I think we are moving into the beginning of what is a post neoliberal order. How it ends and where it goes, I think, is an open question. But I do have a great deal of optimism that we're going to continue with curiosity and authenticity to try to address these kinds of questions. I'd also say that the other source of optimism is when we made a very concerted effort to get outside the Beltway, to speak in terms that were not overly technocratic, to invite people to our conversations, whether it's a farmer, a nurse practitioner, a doctor, a worker, people to our conversations who had a lot of important things to say, who had world life experiences and relevance to our conversation who had not previously been invited. And by reaching out to them, not only did we get smarter and get more worldly in our perspectives, but it also encouraged me and inspired me that there are people there who understand the impact of the work we do, not just from from a demand curve, but perspective, but from the perspective of people who have to live with the consequences, and they get it, and they want to um, um, see change. And so people will say, "Oh, are there leaders of the movement, or are you leader?" The leaders of the movement are the people who are affected by this and who are encouraging change. The rest of us are here to just respond to the will of the people.
Well, you've been super generous with your time. I cannot thank you enough, and you have an energy and an intellectual curiosity and a dedication to doing, I think, what you think is right for people and everyday citizens. And I know I've had a blast watching you in your career and getting to know you. And I can't thank you enough for doing this. And I hope we can enjoy this beautiful space and do another podcast, maybe with some of our guests sometime soon.
A lot of important conversations to have, and I hope to be part of them.
Awesome. Thank you.
Thanks, Teddy. Bye.
Bye.